Welcome to Dekom, Law and Disorder.
The views expressed on this podcast are Peter Dekom's opinions based on his legal experience, research, and academic work. The podcast does not offer legal advice. For any legal matters, always consult an independent attorney who can assess your specific situation. And now, on with the show.
Hi, everybody. It's Peter Dekom, and we're here with Dekom, Law and Disorder, and today, the shadow knows. I'm going to discuss the modern interpretive techniques of the United States Supreme Court. Yeah, we're going to dig a little bit into the older history, but mostly I'm focusing on the here and now. There's a little bit of stuff that everybody needs to know about the past. And in the meantime, all I can say is this country is a mess. And I think my basic belief is that if we can't agree what reality is, then we can't agree on anything. So my minor dedication in all this, and I'll try to keep my opinions down until we're well into this podcast scenario, is that I want to focus on facts. You'll see things about the Federal Reserve coming up. You'll see all kinds of fun stuff, I hope. I call this road candy as opposed to road rage, which seems to be infectious. Road candy means that if you're driving somewhere and you got 45 minutes to spend, I'm going to try to entertain you and maybe throw some basic facts that help us understand the world we're in and make it better for everybody. So, you know what? Let's start looking at stuff. We are a nation of major cities governed by a constitution that was put together in an era of a profoundly agricultural country. Back in 1789, when the Bill of Rights was passed, or 1776, this country was about 95% agricultural. And that doesn't strike anybody probably as being relevant to consider the form of government, but it became totally determinative. I mean, if you're a farmer and you could look at them city slickers, I don't like them, don't trust them none. And the city slickers say, wait a minute, we're importing, exporting, we're making you money. You sell your tobacco, you sell your cotton, you sell all your crops through us. We ship them out from here, go off from our great harbors. And there's sort of a little battle. And you'll notice that even the farmers that were involved, Thomas Jefferson, George Washington were farmers, and George Washington also happened to be a surveyor, and he had a side job running the army. But that was a side job. In the meantime, there was a battle going on. How do we protect vast tracts of land, which are necessary for agriculture, versus people who are in a crowded city and live in side-by-side dwellings or things called apartments, which were still fairly new at the time. But you had brownstones and you had little row houses and stuff like that. People said, it's not fair. The cities have way, way too much power. So Ben Franklin dropped his monocles or his bifocals or whatever he was wearing, put the kite down and said, all right, let's figure this out. We'll have something, we'll call it the U.S. Senate. And we'll have 2 senators from every state, which makes a lot of sense when you're an agricultural, tiny little country that has no particular value with 4 million people in it, isolated thousands of miles from Western civilization. So what are you going to do? All right, we'll create the Senate. And that will someday, said Ben Franklin, looking into the future, have a situation where California will have 39 million people and 2 senators. And Wyoming will have 600,000 people and 2 senators. Doesn't make any sense, but that's what we're stuck with. But to sort of placate everybody else, and this is where a lot of the trouble we're seeing in the Supreme Court today, we're going to have something called the House of Representatives, and it will be based on the number of people, roughly 600,000 people to a district. And we will divide up the states and districts. Only want to let the states do that, because that's not something the federal government should be doing. The state should determine its own districts. So that worked okay. But the Civil War actually screwed us up like you wouldn't believe. After the Civil War, everybody was fighting to take over as many districts as they could. And actually, we even had some weird gerrymandering. That word, it was for a guy named Jerry. And it was the state of Massachusetts. And in 1812, there was a political cartoon showing how Jerry basically mandered the districts in Massachusetts so it looked like a snaky dragon. And that political cartoon, which appeared in 1812, became universally and forever thereafter used to describe distorting districts. Let me sort of give you a verbal statement of how that works. Let's assume you have one great big liberal city and you want to decimate those stupid liberals. So what you do is you divide the city up into, let's say, 5 different, districts. Only instead of having the city divided up, what you do is you have long arms reaching far outside the city, and you actually make that a district. So it looks like an octopus. And each leg of the octopus embraces enough people of the dominant political party to dilute the party that's in the middle. So you'll take a city like Austin, which is about as blue as it gets, and they basically, Austin, Texas, said, okay, we'll give Dems a little teeny parcel here, but we're going to have all those districts reach 100 miles into the hinterland. So our rural folks are going to be voting. So very bright blue Austin, Texas has 5 congressional districts, one of which is blue and 4 of which are red. And all over Texas, that gerrymandering has taken place. And it takes place everywhere. By the way, after the Civil War, them Dixiecrats, they all gerrymandered south, so nobody from the non-Democrats side could ever run anything. So all that gerrymandering was done the other way. The Democrats were doing it, and it was nasty, nasty, nasty. Well, okay, so it's nasty. We like that. We like nasty stuff because that's the country we live in. And we're also looking now, how do you amend the Constitution? Well, you can call a constitutional convention, which I think was done once, never again. And everyone collectively breathed a sigh of relief because, frankly, the ability to amend is, how do I put this it's stupid. We haven't had a new constitutional amendment since the 27th Amendment, which was passed in 1992. And it was a really not very controversial amendment. It basically said, hey, Congress, if you want to give yourself a raise, there has to be an intervening election so your constituents can throw your sorry butt out of office if they don't like the raise you're giving yourself. So that was the 27th Amendment. Not very controversial. I think everybody would think, that's a good idea. But how long did that take to get passed? Hard to believe, but it was actually introduced in 1789 and took 203 years to get passed. So we have the least amendable Constitution in the Constitution democracy world. We are stuck with stuff. The other problem with our Constitution is it was put together in a different era. And I know this sounds silly, but our founding fathers didn't know what the hell they were doing. They basically said, well, let's start this. Oops, that didn't work. Let's do a Bill of Rights to add on to it, make a few amendments, and that'll work. The Bill of Rights basically are most of what we think of when we deal with the Constitution, although obviously later on as the Civil War, which by the way, the Civil War killed more Americans than all the other wars we've ever fought combined. So when you think Civil War is a good way to resolve things, are you willing to be one of the sacrificial lambs? We'll see, and we've already talked about the fact that there's nothing in the Constitution, nothing in our structure of government that allows individual states to secede. Part of this is to say our founding fathers didn't know what they were doing. It's hard to amend the Constitution. And a lot of people say, you know what, the Constitution has to be interpreted in accordance with the culture and historical reality that was in existence at the time that the constitutional provision was passed, the amendment was passed, and we can only look at the Constitution from the perspective of what was there at the time. Now, I have to say on a scale of 1 to 100, this pins the needle at 100 as being stupid. But because if you create a Constitution that is only designed to deal with the society at the time you pass the Constitution, it has very, very limited use. But there's one case that, well, let's talk about actually how you amend the Constitution. We'll talk about the cases that actually amended the Constitution without amending the Constitution. The two methods for amending the Constitution are basically under Article 5 of the Constitution. And one is calls for constitutional convention, which literally has never been used because everybody's figuring if you have a constitutional convention, you have to summarize what the issue is that's going to be resolved is, and then you got to put the idiots in the same room and let them hash it out. Nobody thought that was a good idea then, and nobody's ever thought it's a good idea subsequently. The other one is basically, let's let Congress propose constitutional amendments. And a constitutional amendment requires a 2/3 majority in each of the Senate and the House to then be sent to the state legislatures. So assuming that both Senate and the House vote 2/3 to favor a constitutional amendment, and picture that. Picture the House and the Senate in 2025 deciding, 2/3 of those houses getting together to decide on a constitutional amendment. It ain't going to happen. We hate each other. We won't even talk to each other. There's no flexibility whatsoever. But assume somehow we get that done. Then it goes to the state legislatures. And literally 3/4 of the states have to ratify the Constitution. The purpose for that is so that, the rural states can't gang up on the city states, et cetera, et cetera. So it would have to be sort of a representational vote. If that happens, you have a constitutional amendment. Well, since that doesn't work anymore, we really don't like each other. And we have to basically deal with the situation where people who don't like each other have to deal with change. Now, we have a guy, really one of my least favorite judges. There are some older ones before the Civil War, Taney, for example, and I really dislike. But to be honest, I actually find it very, very hard to have any love at all for a guy named, what's his name again? That guy, Scalia. Oh, yes, Antonin Scalia. This is where I lost respect for Harvard. Okay, I'm biased, I'm a Yaley, but I really looked at this guy and I figured if he were taking a law school class from me, I would have given him a dumbass F. The notion of constitutional interpretation that he employed is something called originalism or contextual originalism. And that basically showed up in one of the nastiest cases I've ever seen, and that is Heller versus District of Columbia. It was decided in 2008. A little bit about a background. We had never had a determination that the Second Amendment, which I can read to you if you want. Let me read it actually here. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The militia, by the way, at that time were the people who fought the Revolutionary War. And that's what it says. And what does it mean, a well-regulated militia? Who are those guys? Well, it was the Revolutionary War dudes. The people who fought the war, took their muskets and flintlocks and blew away Brits in their colorful uniforms. And that's who it was. And they asked Congress, can we keep our guns during peacetime? So if we get called up again, we can just take our guns and do what our duty is needed to be done in 1812. That's it. It was never intended to say every American has a right to have guns. It was not the historical context. But our friend, Mr. Scalia, basically took this case in 2008 after we had an automatic weapons ban that had been in existence from 1994 to 2004. It had an automatic sunset clause. And that provision, which was not ever challenged by any court or anybody, said you can't have no automatic weapons. And everybody said that was a great idea. And the reason that law passed in 1994, with a lot of support from a guy named Ronald Reagan, or a right-wing conservatives, is because someone tried to shoot him. And he got hit. And Brady, his press secretary, got paralyzed, and he became a champion of reasonable gun control, background checks, et cetera, which were contained in various laws. And he didn't believe that, if you go hunting, you probably don't need an AR-15. You probably don't need a machine gun, unless you're mowing down a herd of angry cows coming at you. So we actually didn't want those. But in the mid-1970s, something really strange happened. Vietnam War came to an end in 1975, and the munitions companies, mostly located in Connecticut and Massachusetts, folks, weren't getting orders from the government for guns. So they went to the National Rifle Association and said, hey, NRA folks, I know you're here to help people learn how to use guns safely. We know you're here to help people, children, understand to appreciate how to lock guns and how to take care of them. But we think you could probably help this industry in a big way if you made gun ownership a cultural part of America. And if you do that, then we'll get people buying guns like crazy and our companies will not go bankrupt. If you don't do this, we're going to go BK. You don't want that to happen. So what you'll do, I think, we'll actually give you a whole pile of money. I know you're a nonprofit, but we'll set you up as a for-profit organization to publicize, promote gun ownership. And the NRA said, how much money are we talking about? When the question was answered, NRA said, okay, where do we sign? And you'll notice that there's been corruption throughout the NRA with people spending way too much money on personal things, homes, clothes, trips, jets, and other things that really didn't have much to do with that. But the zeitgeist of gun ownership began to accelerate. It suddenly was so well publicized that by the time Antonin Scalia got his gritty little hands on it in Heller versus District of Columbia in 2008, he basically endorsed this contextual originalism. You can only look at a constitutional provision and amendment within the context of what the world was like at the time it was enacted. Bullshit. That means that the Constitution has no considerable life in it. In fact, that self-same Scalia, basically in 2011 and 2013, when he's giving lectures at places like Texas Christian University and others, was quoted as saying, the Constitution is dead, dead, dead. And that's a direct quote. I think, Mr. Scalia, RIP, you stabbed it to death. So I'm looking at Heller versus District of Columbia. Number one, he didn't deal particularly well with a well-regulated militia. Kind of like skipped over it as if it didn't really have any meaning. And then he decided, I'm going to look at the flintlock and musket world that was in existence when the Bill of Rights was passed in 1789, and I'm going to apply the cultural and historical nexus of that reality to my interpretation. Okay, dude, what different? Why is that relevant? You know, you have a constitution that can only be interpreted within a very, very narrow bandwidth of a very short period of history. And today it's even more ridiculous because technology and the world are changing so fast. It doesn't make any sense. But that's what he said. And you'll look at Amy Coney Barrett, who clerked for Antonin, and she says, well, yeah, that's right. We need to do this originalism and use it to interpret the Constitution. And if a majority of the conservatives on the Supreme Court also did that. So he also did something that was really kind of bizarre. He said, well, the United States was so young back when the Bill of Rights was passed, when the Second Amendment was passed, we need to look at the culture beyond the United States. We need to look at England, where lovely George III was sort of king, and we need to see how they treated guns. Well, he said, well, and Britt said, you have an absolute right to have guns. So the United States, that's what was probably the law and what it should have been. There's one minor catch with that. That is a complete and total misstatement of British law at the time. Originalism to me means that the Constitution isn't particularly valuable. The way we have the Constitution, Article 5, how we amend the Constitution, we couldn't do that if you put a gun to everybody's head. You cannot get 2/3 of the Senate and 2/3 of the House to agree on proposing something. And if you look at the Equal Rights Amendment, which should have passed, it had within it a sunset clause. It didn't. It didn't get the necessary number of legislatures. 3/4 of the legislatures have to approve it. It didn't happen. Equal Rights Amendment died an ugly, writhing death. So now you have courts like Heller versus D.C. and Mr. Scalia deciding, well, I can amend the Constitution just by interpreting it my way or by imposing rules of interpretation that were never, ever, ever envisioned by any of our founding fathers. They make absolutely no sense because if you require everything to be reviewed within the nexus of the historical context at the time the provision was passed, You turn jurists, judges, into historical researchers. That's not what they're trained to do. They're trained to look at legal precedents, things like stare decisis, things like that, res judicata. Those are crazy-ass Latin terms for, we made this decision already. But now you've thrown this loop, and you can basically, and believe me, if you want historical context, do you know how many opinions about what happened in history are written at the time and afterwards? You can probably find justification for anything that you want. And so that was one of the nastiest things that happened, and it still happens today. But that wasn't enough. The Supreme Court said, you know what? We need more power. Okay, so we now have a Supreme Court with 6 conservative judges. It can actually go down. I can even tell you who appointed whom and where they came from. Let's start with the Supreme Court. Chief Justice John Roberts. He was appointed by George W. Bush in 2005. But he was the oldest judge in the court in terms of years on the bench. The other George Bush, H.W., nominated a guy named Clarence Thomas, one of the most corrupt federal jurists in the history of the court. But since the Supreme Court doesn't actually have an enforceable ethics requirement on their judges, unlike every other judge in the federal system, he basically can take, I like that Winnebago. Hey, can I go on this hunting trip? Will you pay for my hotel? No, I want a better suite. Oh, no. Will you pay for the school for my nephew? Would you? Hey, how about my mother needs a house? Would you buy her a house? And all that stuff happened, and nothing happened to Clarence Thomas. He's been there since 1991. And I think the plans under the Trump administration are for him to retire near the end of Trump 2.0, and then have Trump, appoint a substitute. Maybe a teenager, no, probably somebody a little bit older, but someone will be with the court for 40 or 50 years who's as conservative as Clarence Thomas. Clarence Thomas is a bad judge. The next one, oldest, is a guy named Samuel Alito, and he was appointed actually in 2006. And he came from the Court of Appeals, and he was George W. Bush's appointment to the court. Not exactly a wonderful situation. But we have others. We have Sonia Sotomayor. She was appointed by Barack Obama. Elena Kagan, she was appointed, let's see who did that, also appointed by Barack Obama. And Neil Gorsuch and Brett Kavanaugh appointed by, and Amy Coney Barrett appointed by Donald Trump. And the last appointment after Judge Breyer retired, is Ketanji Brown Jackson, and she was appointed by Joe Biden in 2022. That's who the courts are. Right now you have a 6-3 conservative majority, and I have to say that 6 is a very conservative majority. And let's talk a little bit about how the Supreme Court makes outrageous rulings without making rulings. Huh? The shadow knows. It's called the shadow docket. And the shadow docket are basically supposed to be emergency rulings and used very, very sparingly. Well, unfortunately, given the number of executive orders funneled out by Donald Trump, we don't have a few of those. We have a flood. Because every time Donald Trump decided he really didn't need Congress to make any decisions because he could make all of them. And so executive order after executive order after executive order, including a few suggestions from the great Doge, not from Venice, but the Doge. Elon, I don't talk to Trump anymore, Musk. You basically have a litany of challenges. People who are fired for no particular reason, even though they're supposed to be in the civil service. Allocations of money that Congress, basically passed and were signed into law that Trump decided he didn't want to spend. And it got to the point where the president of the United States said, wait a minute, I need more. I actually want a decision from you dudes and womans where I have immunity from anything that I do because, I don't know if you remember this, if the president does it, it can't be illegal. Who said that? Oh, Richard Milhouse Nixon, when he was in the middle of the Watergate scandal. So he basically, his position, mirrored almost word for word by Donald Trump, was if the president does it, it can't be illegal. And this sounds crazy, but the Supreme Court said, okay, that sounds reasonable. We don't want to get in his way. If he does something illegal, someone said, what if he shoots somebody? It's a risk we'll take. I don't know about you, but the idea of equal protection under the law, the word equal should have some validity. But the immunity decision, Trump versus the United States, was something where the court actually gave the president immunity for anything that could be arguably connected to something he's got to do in office, and he cannot be prosecuted for that. Trump tried to get it to apply retroactively to the E. Jean Carroll litigation for sexual abuse. Courts wouldn't let him do that, but there's a lot of controversy about how that would work. The shadow docket is when someone goes to the Supreme Court and has standing. That means they're qualified. The Supreme Court doesn't have to hear most pieces of litigation. There are very few places where the court actually acts as a court, which is basically to have a trial and have fact-finding. With the exception of situations where the Supreme Court has something called original jurisdiction, where the trial actually takes place at the Supreme Court with witnesses and everything, and that's almost always relegated to things like one state suing another state, and so that gets litigated before the court of original jurisdiction. But this is a little known fact, and it has to do with facts. The Supreme Court is not a fact-finding court. Huh? No, they can't actually say, well, we can get someone, an expert, to tell us what that means. No, you can't do that. Testimony to determine facts cannot take place at the Supreme Court level. You can't submit declarations in proof of facts at the Supreme Court level. If the Supreme Court needs additional facts, what it will do is remand, send back the court's decision to lower courts to do the necessary fact-finding. The court itself will not fact-find. But sometimes the court facts-find just applying its own opinions, its perception of the world. But so now somebody files a case, and the Supreme Court doesn't want to hear it right away. There are two kinds of cases in the ordinary course of cases. One are docket cases and others are merit-based cases. A merit-based case is an argued trial hearing, appellate hearing, where you have briefs, oral arguments, counter briefs, etc. You may have amicus curiae. Those are friends of the court submitting their opinions, and the court may or may not accept those. So the court looks at this body of briefs and testimony, etc., and makes a ruling on the merits. And generally, the Chief Justice will assign one of the judges to write the majority opinion, and other justices are welcome to join that opinion, or if they agree with it but they have other reasons or qualifications, they might write their own version. That's called a concurring opinion. And if you don't like what was said and you want to make it on the record, that's called a dissenting opinion. That is a fully argued case on the merits. The other one is, hey, court, I need an answer quickly. Please come. Look what they're trying to do. They're trying to stop me from throwing immigrants out of the country. Oh, look, they want me to keep the stupid, person that I don't want to see on the Federal Reserve, and I need a decision fast. And so what the court will say is, okay, we will hear this, but we have several choices. One, we can accept the decision of the appellate court or the trial court, whichever was the preceding deciding tribunal. We can take that and we can say, okay, for the time being, that decision will hold. Or they can do what they've been doing way too much, and is, you know what, we're going to reverse the lower appellate court, put it back the way it was, as if there were no courts, and let the world continue until we decide to hear the case on a full merit review. We may not do that for 6 months or a year or two. But in the meantime, this interim ruling, which doesn't have an opinion, there isn't a majority opinion because there wasn't a briefed, oral, presented, argued case. So you get this Like you'll get a 6-3 decision that says, okay, we reverse the other court and we won't deal with it till we deal with it. The problem with that is the decision not to hear the case and leave things at a particular frozen status quo is a decision. And since it can take a lot of time between the time that this shadow docket, emergency docket, stayed the proceedings, maybe a year, well, that could change the whole earth. I mean, tariffs, if you read the Constitution, there really is no justification for the President of the United States to embrace tariffs. That power is exclusively given to Congress under Article 1. But Congress passed a weird economic emergency act that sort of suggested that the president could react to emergency situations, putting the country in jeopardy. And Trump decided, okay, all the tariffs all around the world, except for ones from specific treaties, they're threatening us. Wait a minute. How did they become an emergency? They've been there for 20, 30, 15, 10 years. Emergencies generally happen quickly. They don't kind of, I'm an emergency. I'm coming. Get ready for me. I'm an emergency. I'll be there in a year. No, maybe 2. So the court, for some obscure reason, bought into that. Now, right now, we have executive orders which look a whole lot like statutes. And we're seeing executive orders being issued at a rate of, put it simply, the same number of executive orders that Donald Trump has issued to date. Joe Biden issued the same number. Only he didn't do it in 8 months. He did it in 4 years. So the court is being flooded with executive orders with that signature that's a little contested. That's going to be probably a podcast of another time. But we really have a very complicated situation here with the shadow docket, because the Supreme Court will not make a decision and freeze things in a particular course for a year or 2. That's often the decision, because everybody adjusts to the way the law is at the time they're trying to make decisions and do things. So as a result, those tariffs are in place. And that's great, except for one thing. If they were not lawful, we've got somewhere around $160 billion, or going up to trillions, that we're going to have to refund. And so what Trump is saying, well, you can't rule against my power to set those tariffs because the country will be saddled with this massive debt. I will put it to you a different way. Because I screwed up and violated the Constitution so egregiously, you can't undo that because the damage to the country is too big. So the bigger I screw up, the more power I have to have. That doesn't seem like a good argument, but it is what people are seeing. Now, the federal bench of retired judges, let me just pull this out here. It's called Federal Bar Association Panel. And a lot of judges took a look at the shadow dockets. And they basically said, you're making these rapid decisions. And unfortunately, these rapid decisions are changing the country. And no matter what happens now, if you don't resolve the issue completely and fairly and immediately, well, you're basically making a decision. And you're making a decision in a way that was never anticipated for you as a Supreme Court justice. You're making a decision with no briefs, no oral arguments, no amicus curiae briefs, nothing. You're just shooting from the hip. And that is a pure political decision. And it actually has worked out that what the Supreme Court has been doing in shadow dockets is nothing more than that. Now, you look at people and, everybody wants to have organized immigration. I mean, obviously we want to have secure borders. It's important stuff. But when you basically decide that the Constitution does not apply to anybody except U.S. citizens, and you go that way, by the way, that case was decided in 1945, in which a foreigner was basically being tossed out because the foreigner expressed an opinion that was unpopular with the administration in power. 1945. And he filed a lawsuit. And that lawsuit basically said, wait a minute, I think the Constitution applies to anybody who's being impacted by an order. And I got here on a legal visa, so what are you saying? I don't have First Amendment rights? And the court said, anybody who is within the borders of the United States is subject to the constitutional protections of the Bill of Rights and any other applicable constitutional provision. You cannot discriminate against somebody because they're not legal. So, okay, I got that. But the Supreme Court has been reshaping the country, which, by the way, other Supreme Courts has done that too. The last time the Supreme Court went crazy about this, you have cases like Plessy versus Ferguson in the late 19th century saying separate but equal is cool, or just before the Civil War, basically saying slaves have no standing to file a lawsuit because they're not people under the Constitution. A lot of really bad decisions over the years. But we started, at least recently, the court decided in something called Holder versus Shelby County or Shelby County versus Holder to repeal large provisions of civil rights legislation, notably the Voting Rights Act, that had taken place, and noted that certain states, there were 9 states listed, had a bad habit of discriminating against people of color. And so the Supreme Court put those states under federal scrutiny, and the federal government had to make sure that they absolutely applied those fairness decisions to getting people to vote. Well, Shelby versus Holder basically, and that was like, 10, 15 years ago, basically said, no, that's an old law. It's so old. By the way, it's been amended several times since. So not like it just came from the early 60s. It was amended several times in the 80s, et cetera. But the Supreme Court decided, no, those are trustworthy states. We can take the federal supervision. They're not going to discriminate against people of color. So we're going to throw that part of the Voting Rights Act out. Within a week, they all put back all the voting discrimination they ever had before, and there was no appeal. We also have the court basically saying, we want to get the Supreme Court out of what we call states' rights. And Article 10 of the Bill of Rights basically says, you ready for this? The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Huh? What? So that means people who don't like the laws that the federal government is doing is saying there's nothing in the Constitution that makes this happen, so therefore it must be a state prerogative. And that begins to get us into deep and nasty quagmire land. Deep and nasty quagmire land means all of a sudden you can make decisions that are purely political, highly weaponized, because they're not forbidden by the Constitution. Why are they not forbidden by the Constitution? Oh, because the Supreme Court doesn't interpret it that way. You see the catch-22 here? The Supreme Court doesn't like a provision, and so it says, well, we don't interpret the Constitution as supporting that. We basically look at that as, nah. And what's really going on that's very, very interesting is Donald Trump has a clear goal. He said it way back at the beginning of this Trump 2.0. I want to be a dictator for a day. And then he kept saying, you know what? I think a dictator would be a more efficient way of governing. And about 30% of the United States says, screw the Constitution. It's an old raggy thing anyway. Let's just get as efficient as we can to implement our right-wing agenda. And Trump said, okay, I can do that. I'm going to, I believe in Christianity. I don't believe people, I'm not saying that we're going to have a state religion because that's banned by the First Amendment, but that doesn't mean we can't be a Christian nation. And it doesn't mean that we can't be a little bit favorable, look at all this discrimination against white people. We can't have that anymore. All these white people need to have equal rights, just like black and brown citizens. And everyone's saying, huh, what? Well, and then let's have this thing with religion. All you universities are discriminating against Jewish kids. And by the way, if you poll the Jewish kids and you poll Jews within the United States, do they believe that anti-Semitism, which is Trump's rallying cry, is a justifiable reason to take over and cut funding to our research universities and re-examine their curricula and take them over, etc. Unfortunately, when you have a Supreme Court that makes a cultural decision, a political decision to embrace a particular philosophy in everything that it does, you get a major shift. I sit here and I think to myself, well, I'm doing this podcast. If I say things the government doesn't like, I have First Amendment rights, and I was born in the United States. I'm an American citizen, so I'm fine. And then I start thinking about it. I think, boy, if this thing gets too popular, someone's going to put a bullet in my head or carry me off into a prison. Well, my age, no big deal. Maybe it is for my family, and I won't know the difference because I'll be dead. But I don't like the idea that I even have to worry about that. I don't like the idea that I have friends who are brown and family members, et cetera, who are of Hispanic heritage, and they carry their passports with them. You remember how people were carded in Germany in the 1930s? Huh? If you were a Jew, you had to wear this, the Jewish star pinned to your clothes. And if you had a store and you were Jewish, you had to have the sign Juden, which means Jew, on the outside of the store. And you start looking at these little trappings and we say, well, we're not Nazi Germany. Neither was Nazi Germany before it was Nazi Germany. You had a little guy who basically said, you know what? The Europeans got too much out of World War I in terms of reparations, and I'm going to undo that. I'm going to make Germany great again. That's I've heard that somewhere. I'm not sure where it is. We watched the Supreme Court, deal with gerrymandering in a very weird way in a case from 2019 called Ruccio versus Common Cause. And Chief Justice John Roberts basically determined that a very obviously discriminatory gerrymandering was basically okay because, as he explained, the federal courts cannot hear partisan gerrymandering cases because there are no, quote, discernible and manageable standards, close quote, with which to identify these gerrymanders are unconstitutional. If you say all black people are going to be in this district, that will be unconstitutional because you picked and named a class in the statute. But what this case basically says is, if you can manipulate the gerrymandered districts, have at it. The other thing that the Supreme Court did is they said, okay, we're worried about rogue justices. I think the Supreme Court has got filled with those, but rogue justices who take it upon themselves to make a ruling that a particular federal regulation or statute or the way a state applies it or the way an administrative agency applies it, if we make a determination at that trial court jurisdictional level, that decision about constitutionality or an unconstitutionality is the law only for that jurisdiction. So you could have 6, 7 districts across the United States with conflicting visions of how to interpret a constitutional provision. And let's face it, there's enough appellate protection for people that if in fact an individual judge makes a decision which is completely ridiculous, there is an appellate court where emergency action can be taken quickly. But if something is obviously unconstitutional, and that's only going to hold, let's say, for the Ninth Circuit or California or whatever it is, but not for Indiana and states, Ohio, how do you run a country like that? You can't. But the court said, we'll live with it. And that's the way it goes. Ultimately, what I like to believe the Supreme Court should be doing, and it definitely isn't doing, is saying, look, we want to protect, the majority does rule with one huge caveat, not at the expense of minority rights. That's the essence of the United States of America. The Constitution is not there to protect ordinary citizens in doing ordinary things. It's there to protect the individuality that differentiates us religiously, politically, intellectually from each other. And to the extent there are differences and they become illegal, that's what the First Amendment was supposed to protect us against. You remember back when the country was founded, the colonists were made up awfully a lot from people who practiced religions, Huguenots, whatever they were in Europe, and they were being, arrested for their religious beliefs. So they came to the New World because they believed here they could be who they are. And in fact, they were. And everybody respected that. Over time, this notion of we are white Europeans, this country belongs to us. And I keep thinking, wait a minute, did you cross the bridge across Alaska from Russia thousands of years ago? Because, we killed those guys. So it's our land because they're dead. Got it. Or dead or poor or living in, really bad pueblos or reservations. So clearly we're the ones who won. That's not what this country was designed to do. And if, in fact, we create a homogenized universe where we all have the same ideas and we all have the correct thinking and we all adhere to that, what do you think is going to happen to technology growth? What do you think, and the other things that happen, what do you think happens when big money comes up against ordinary people? We already know we're in a society where trillionaires are making decisions, where trillionaires are getting tax cuts, where people who are making $25,000 to $100,000 a year are getting benefit cuts. Medicaid is going. So at the end of all of the stuff, the Constitution is there to incent diversity. It's a bad word because diversity means you're going to discriminate against white people. You know what? I'm a white people. I'm European. I'm Protestant. I hit all check all the boxes. But I cherish diversity. I mean, it's kind of like, wait a minute. Do I want to go get a hamburger every day? Or I wouldn't mind a pizza, some pasta, some Chinese food, something? Diversity is what made this country great. You get a bunch of people with different ideas, put them in a room, and spark creativity, whether it's a movie or whether it's a new form of technology, artificial intelligence, whatever it is. Diversity creates value. And this country is great because we fostered that value. To take it away, to make life more expensive for everybody, to treat people of color who are here because they want to work hard, who, by the way, have lower criminality rates than people who are citizens, and take them, put them in prisons where they're locked up in cages, chain them. They're hardworking human beings, and our society needs them. Want to see what this all has done? Take a trip to Las Vegas. Drive through Vegas. You want some quiet alone time? Drive down the Strip. Hotels are empty. People aren't, going out and enjoying their life. And that's true with a lot of small businesses. A lot of restaurants can't exist. Hotels can't exist. Construction can't exist. In the end, how we treat those without power defines what we think of ourselves, what we think of our own country, and what we think we should be in the future. If this is the future where you basically find brutalizing human beings, demonizing human beings, just because they're different, and that's a good thing, it ain't my country. And I'm trying to basically convey facts about what we are, where the Constitution comes from, so that you, as Americans or people living in America or people who picked up this podcast in other countries, are wondering, who are these people? Well, you know what? I like to believe that we're nice people. The majority of Americans are unfortunately too complacent about political realities. They let things happen thinking, it won't happen here. Well, it does happen here. And most people, most Americans, most everywhere I've been in the United States, and I've been all over this country, I've met an awful lot of really nice people. They don't call it Southern hospitality for nothing. It's a wonderful place to spend time where people look at you and say, can I help you? All y'all are just great. And I will say to you until next time, this is Peter Dekom, Law and Disorder, and I'm trying to find a little bit of order. Thank you.
If you would like to give feedback, suggestions for new topics, or have a question that might be selected for a future podcast, please email us at dekompodcast@gmail.com. Thank you for listening. Until next time.